Good afternoon, colleagues. We're here to talk about something so small it fits in your pocket. A tiny square, a glowing button on your screen, among many others. It doesn't look threatening, it doesn't look powerful, but oh my, it is. That little square is not just a logo like you might be used to with other ones. It's a condensed form of everything a brand represents. It's a digital handshake with the user. It's what they tap when they want something from your client or from your own company if you're inside counsel. And in that tap, trust is born or broken. Today, we're talking about app icons. But really, we're talking about identity, authority, and survival in the brutal ecosystem of mobile business. Consider this: we live in an era where an average person makes thousands of different decisions per day. Most of these happen subconsciously. What to wear, which route to take, which app to open. Your icon participates in this cognitive battlefield every single moment it appears on the screen. It must win split-second decisions against competitors. This isn't about graphic design, it's behavior economics compressed into those small pixels. The icon that hesitates, that requires even a microsecond of extra thought, loses. And in losing that moment, it loses revenue, user retention, and ultimately market position. App icons are today's totems. Totems in the old sense, carved symbols carrying meaning, allegiance, even mythology. And like any totem, the app icon condenses a narrative into a symbol. It doesn't live in a store window, it lives on the screen, on the lock screen, on the home screen, on the watch face. The most powerful icons, they're not flashy, they're sticky. They make you feel something before you even realize it. Let me ask you, when was the last time you tapped a gray icon with no emotional pull? I'll tell you, you didn't. A grayscale mode is the way to reduce your addiction. When I tried it on my own iPhone, I felt confused, disoriented, uneasy. The icon you tap is the one you remember. This is the space we're playing in. And yet, so many companies treat icon like a decoration, something to slap on at the very last moment. But when that icon becomes a battlefield marker for your entire brand, neglect is no longer an option. The neuroscience here is fascinating. Studies show that humans process visual information much faster, some say like even 60,000 times faster than text. So your icon has roughly something like 13 milliseconds to trigger recognition before the user thumbs moves on. In that microscopic window, color psychology, shape recognition, and brand memory all collide. Apple understood this when they created their own icon, a perfect circle that breaks the rigid square constraint, immediately distinguishing itself. Instagram's gradient didn't appear by accident. It triggers the same dopamine response as a sunrise, tapping into millions of years of human evolution. Your icon isn't just competing with other apps out there. It's competing with fundamental human instincts about what deserves attention and what gets ignored. Let's look at some numbers. The average smartphone user touches their phone something like 2,000 times a day. Many of those touches land on apps, and every app tap is preceded by one thing: an icon. Your app icon could be seen hundreds times per day. That's more than a business card, more than a website, more than any billboard one could ever buy. Think about it. And unlike marketing campaigns which fade, this icon is persistent. It fights for attention every single day. It fights in chaos, competing against hundreds of other apps, each desperate for a thumb tap. And no one ever taps an icon they don't trust. Trust in the world of app icons is visual. It's subconscious. It's built pixel by pixel until one day it can be hijacked or just stupidly lost. So, how do you create an icon that's defensible? Not just legally, but also strategically. Let's break it down. A great icon is not a piece of art, it's a psychological anchor. Yes, I'm talking about soft stuff even in a hard track. It must be simple but unforgettable, unique in shape, color, and tone, tied to your app's essence, not just function. Contextually aware, global enough to scale, but sensitive enough not to offend anyone. Here's the test. Put your icon on a cluttered phone screen. Scroll quickly. Blink. If your icon vanishes from your site, it doesn't matter how beautiful it is. It's invisible. And invisible icons are indefensible. The best icons earn memory. They punch above their pixel weight. And in fact, the strategic dimension runs deeper because your icon must work across cultures, across operating systems, across device types. So it should work as good on the phone as it does on your watch screen. So it needs to maintain its identity, whether it's rendered in a dark mode or in a light mode or through different various accessibility functions. Let me be blunt. Most icons fail, not because the designer lacked skill, but because the founder lacked strategy. Here's what you shouldn't do. Don't copy what's already winning. You're always going to be a lesser version. Don't default to cliches. A card for shopping, a bubble for messaging. That's laziness in disguise. Don't rely also on a single letter unless your brand is already synonymous with it, like the Facebook's F or Netflix's N. There are a limited number of letters in the alphabet, you know? The point is also that icons don't explain. They must evoke. The most successful icons often have zero literal connection to their function. What does Twitter's bird before it became X have to do with microblogging? What does Apple's bitten apple have to do with computers? Nothing. And at the same time, everything. They created emotional territories instead of functional explanations. The strongest icons transcend the literal meaning and become pure brand essence. In fact, that WhatsApp speech bubble is perhaps the last major app that could get away with the literal representation. Here's the brutal truth. If your icon blends in, it will bleed value. IP law is not about beauty, it's about distinctiveness. If your icon is too close to thousands others, no court will protect it, no user will remember it, and no investor will value it. Distinctiveness is your legal armor. It's what transforms a symbol into a property. It's what allows you to say, this is mine. I built this, and you may not touch this. If your icon disappears in a crowd, then in a court it will not stand. And that, even if you get to the court with it, meaning if you succeed to get it registered as a trademark in the first place. Does it mean that everything must be complex and there is no space for simplicity? No, absolutely not. In fact, just recently, EU IPO's Board of Appeal reversed an examiner and allowed a rather minimalist icon you see at the bottom of the slide for the Open Home Foundation. The decision shows that even ultra-simple icons can pass, but only if you prove they aren't an industry cliché. This is big news for app designers relying on pictograms. The legal landscape here is evolving rapidly. Traditional trademark law developed around physical goods, but app icons, they exist in a compressed visual space where micro differences carry macro significance. And courts are increasingly recognizing that in the app ecosystem, elements that might seem generic in other contexts can become distinctive. And the key isn't complexity, it's that contextual uniqueness. Now, let's talk about classes. Trademark, as you know, is not registered per se. It's registered in connection with specific classes of goods and services. Let's quickly go over them. As a starting point, downloadable software falls under Class 9, while the digital service or platform aspect typically fits Class 42. But beyond this, a good idea is to map the app's core functionality to relevant classes. For instance, a messaging app may also involve Class 38 for telecom-related services. An e-learning app likely touches Class 41. A fintech offering may need Class 36, and a health monitoring app could implicate Class 44. We must also think laterally. Will we or your client sell branded merchandise? Then Class 25 or Class 16 may apply. Will the app provide business management tools? That invokes Class 35. Finally, a great idea is to include foreseeable adjacent classes to avoid leaving gaps as the product evolves. Properly scoping classes before filing saves costly extensions or oppositions later. Also, always bear in mind that you can't just extend the scope of your registration. If it's not filed immediately, at least in Europe, the US, and most of African countries, you will need to file another application if you figured out that, for instance, something is missing at a later stage. The strategic implication of class selection extends beyond just legal protection. Each class essentially represents a potential revenue stream or business model expansion. When Uber, for instance, have started, they might have focused on class 39, which is transport services. But their expansion into food delivery, freight, and financial services required broader class coverage. Your icon will represent all these services, so your trademark strategy must anticipate business evolution. Missing a critical class early can mean years of legal vulnerability or expensive opposition proceedings when competitors notice the gaps. So, as I said, mapping is a great idea, but how to approach it step by step? So, you start by mapping every feature or service your app offers to the NICE classification, starting with the basics, meaning, is it a downloadable software or a cloud-based service? Do you need class 9, 42, or both? Next, consider the business model and the distribution channels. If your app, for example, will tie into e-commerce of physical goods or offer training modules, include those classes up front. Conduct thorough clearance and competitor searches in the relevant jurisdictions to see which classes peer apps register under. This is great for both inspiration and to spot potential conflicts. Then think ahead. If you plan to add new features or expand internationally, check how those classes work in each market. There might be differences in practice. And never forget, app is international by definition. So checking at least the major markets is a very, very good idea. Finally, use the classification assist tools to refine the list. This disciplined approach will ensure the robust protection without overpaying for unnecessary classes, and at the same time making sure that you actually cover everything that makes sense to cover. This international dimension that I mentioned, it adds crucial complexity. Despite efforts to harmonize, you have different wordings. There are nuances of interpretations. Some countries have first to file, other ones have first to use. So you need to have a very good understanding of what your core markets are and what your second choice markets will be. Have a very good business understanding of that. Now, let me walk you through two stories. First one is Planet Art versus Photobox. Planet Art launched an app called FreePrints. Simple premise, print photos straight from your phone. The app gained traction, millions of users, clean, bold icon, high recognition. And then Photobox launches a similar service with a disturbingly similar icon. So Planet Art sued, obviously. And to add insult to injury, Photobox also used an indication, free prints. Not so much as a name, and free prints, after all, is a descriptive. But if you compare the icons themselves, you see them now on the screen, the color choice is similar. Well, the image is clearly different. So if these were the big trademarks used on packaging, it might have been fine. But we're talking app icons. Their overall look and feel on a small square, certainly confusing. Enough that customers clicked on the wrong app. Enough that brand equity was leaking. Also to note that in a digital app marketplace, even descriptive terms can be protected as trademarks, and the context and presentation matter here big time. It's all, of course, the classic legal it depends. But the use of similar color scheme and the style played a huge role here. Again, we're talking small square. There are nuances when we're talking about small squares. So Planet Art won because the court agreed the app is icon is the brand, and confusing it dilutes value. Another case, Pinterest versus Pintrips. Pinterest is a massive platform, famous app, visual discovery, household name. Pintrips, a small startup, travel planner. Different products, yes, but Pinterest is also famous. Wouldn't it work to claim well-known trademark? Maybe. But Pintrips, in contrast to Photobox, in the previous example, did not resort to copying the logo. The court ruled on that there is no likelihood of confusion between the trademarks and that there was a fair use of the word pin. These cases show that icons matter. They're not surface-level assets. They're strategic property. And they're very specific app nuances to take into account. Traditional trademark law focuses on likelihood of confusion in marketplace encounters. But app stores, they create a unique environment where users make split-second decisions in compressed visual spaces. The same color palette that might be acceptable on billboards becomes problematic when rendered at 60 on 60 pixels. Courts are recognizing that app icons operate under different rules. They are simultaneously more protected due to their concentrated brand value and more vulnerable due to their limited differentiation space. The Free Prints case established that even small visual similarities can constitute infringement in the mobile context. This creates both opportunity and risk. Your distinctive icon gains stronger protection, but you also face higher scrutiny for any similarities to existing marks. The legal precedent is clear. App icons aren't just logos. They are the primary brand touchpoints in digital commerce. So trademarks, that we discussed. But is it truly it? How do you really protect an icon? Well, what you certainly don't do, you don't rely on a single method. You layer. Trademark protects the name and symbolic association, your distinctiveness. But there is more. You have, for example, designs. Design rights protect the visual appearance, the actual shape and layout. You also have copyright. Copyright protects the original creative expression. There are, of course, nuances about each of them and different requirements to obtain protection offered by this or that specific instrument. But why would it be wise to consider all three? For starters, because attackers are clever. If your protection is one-dimensional, they'll go around it. But layered protection, according to me, it's not an overkill. It's about resilience. Trademark might protect your icon's use as a brand identifier, but not its artistic elements. The goal isn't just to win individual cases. It's essentially to make legal challenges so expensive and complex that competitors will choose different paths to market. So let's quickly discuss what design has to offer. Locarno Class 1404 is specifically designated for screen displays and icons within the International Locarno Classification System for Industrial Designs. This subclass was introduced in the 8th edition of the Locarno classification, still in 2003, to address the increasing importance of digital visual elements in technology and user interfaces. Design protection via registered designs and trademark protection serve different purposes, but can absolutely complement each other. Here's why design protection might be preferable or even beneficial in certain cases. First of all, in terms of scope of protection. Design protection covers the visual appearance of the app icon, including its shape, colors, layout, graphical elements. It protects against direct or similar copies, and what is especially important, regardless of whether they cause consumer confusion or not. Trademark protection, as mentioned already, focuses on brand identification. It prevents others from using similar icons that might confuse consumers about the app's source. Second, in terms of legal requirements, design protection requires novelty and individual character. So the design must not be identical or overly similar to prior designs. No proof of distinctiveness or market use is needed. Trademark protection, on the other hand, requires use in commerce and distinctiveness. The icon must function as source identifier. Generic or descriptive icons often fail to qualify. Third, in terms of duration and cost, design protection typically lasts up to 25 years, 5 initially and then renewed every 5 years, and is often cheaper and faster to register. For example, EU designs can be approved in a couple of weeks. Trademark protection can last indefinitely, with renewals every 10 years, but it also involves higher costs and longer examination periods. In terms of enforcement advantages, with design protection, you don't need to prove copying or consumer confusion, only the fact that infringing design is too similar. Trademark cases require evidence of likelihood of confusion. You see, combining just those two forms of protection already enhances your IP position. So consider using design protection early to secure rights while building the icon's distinctiveness through use. Then back it up with trademark protection for perpetual coverage. That could be at least one way to go. Is that the best one? It depends on the business. The strategic timing here creates a powerful protection cascade. because design rights, they offer immediate protection without requiring market presence or distinctiveness. It's perfect for pre-launch apps, for example. And also, additionally, design rights are increasingly valuable in App Store disputes because Apple and Google can remove apps for design infringement without the complex likelihood of confusion analysis, which is required for trademark claims. This means design rights offer faster, more certain enforcement in the design marketplace, in a digital marketplace, sorry, where speed often determines the outcome. But whatever you do, act in advance. Here's the bitter truth. If you act after the infringement, you've already lost. You've lost trust, you've lost brand clarity, and you've probably lost quite some money. The only real protection is preemptive. You must embed IP strategy before launch, not after the marketing team designs the icon, not after the app hits the store, before, from day one. Build the fence before you plant the tree. And by the way, a small side note still on protection, if you consider designs, remember this. Publicly disclosing the icon to build trademark distinctiveness before filing for design protection may void the design's novelty requirement. That novelty requirement is not something that will be checked at the moment of filing for design protection, but your design can be invalidated because the novelty was compromised. So, moving on. Layering, that's good, but it doesn't stop at just adding designs. It's also about contracts. Too many founders assume that paying a designer means owning the design. It doesn't. Unless your contract explicitly transfers all rights in all jurisdictions for all uses in perpetuity, you do not own your icon. You've just rented it. And if that designer disappears, changes terms, licenses it somewhere else, guess what? You're exposed. Every IP contract must be clear on what is transferred, clear on where and how long it applies, include originality warranties, include indemnities against third-party claims. You don't need a dozen of pages, but you do need that clarity, because ownership only matters when it's bulletproof. The contract architecture here requires really surgical precision. Standard work for hire clauses often fail internationally because many jurisdictions just don't recognize the concept or apply different standards. European moral rights can't be waived, meaning designers retain certain rights even after assignment. Some countries require written assignments to be notarized or registered somehow. So the safest approach is comprehensive assignment language that covers both economic and moral rights where applicable, combined with exclusive licensing where assignment isn't recognized. Additionally, specify that the designer warrants originality and hasn't incorporated some sort of copyrighted elements from other sources. Include indemnification clauses requiring the designer to defend against third-party claims. Most critically, ensure the contract covers derivative works. Your icon will evolve, and you need clear rights to create these variations, animations, and adaptations without returning to negotiate with the original designer. Subcontractors are, in fact, very often overlooked. But if they touch your icon, they touch your IP. And unless your contract chain is unbroken, your ownership claim is vulnerable. Here's the scenario. A freelancer, let's say in Argentina, designs your icon. You pay, you launch, 3 years later, you're acquired. And suddenly, the due diligence reveals that freelancer never assigned copyright in your visuals, app, icon including. And this is when your entire valuation might witness a drop. Protect the chain, audit the contracts, educate your team. Don't lose millions over a missing signature. You say this is stretched? Yes, there are luckily not many cases indeed where the designer had sued the company, but they are not non-existent either. A recent case from 2024 that involved Jim Pons, who designed a logo for the New York Jets. Pons filed a lawsuit in federal court in the US seeking to be recognized as the copyright owner of the Jets logo and accusing the team and the NFL of copyright infringement. His complaint argues, amongst others, that the team never obtained a formal assignment of rights from him. Pons is seeking a share of revenue generated from merchandise featuring the logo. How about that? Would you like to find yourself in such a conundrum? So, contracts. I guess it's best to be safe than sorry. Um, the goal isn't just clean ownership, it's demonstrable clean ownership that survives rigorous institutional scrutiny. Let's end where we began. This is not only about aesthetics, it's about identity. It's about sovereignty in the age of copy paste. So, for the really good logo for an app, remember, be original. Because imitation may be flattery, but it's not defensible. Be consistent, because brand drift weakens memory. Search thoroughly, because ignorance will not protect you. Make sure you thought twice about the exact scope that you require. Protect in layers, because redundancy is strategy here. And finally, own completely, because half ownership is a myth. You either own it or you don't. The app icon is not a decoration. It's a promise. It's a flag on a digital battlefield. It's something your customers will see every single day, something that will accompany them to the boardroom and to the bathroom. You cannot get more intimate than that. Protect it right, or risk becoming a whisper among screams. In the final analysis, your app icon represents a convergence of art, law, psychology, and business strategy. It's simultaneously your smallest asset and potentially your most valuable one. The icon that works transcends its technical function. It becomes a cultural artifact that users carry in their mental inventory of trusted brands. In the world of apps, it represents your brand in their pocket, in their bag, in their life. This isn't a hyperbole, it's a mathematical reality of human app interaction patterns. The companies that understand this create icons that become part of users' daily rituals, visual shorthand for entire categories of human need. Your icon is a permanent ambassador in the attention economy, so treat it accordingly. Thank you very much for your attention. On the screen, you see the QR codes that will lead you directly to my LinkedIn profile and to the website of my company, as well as books that I have published and that is coming soon. Thank you very much.